welcome everyone. We have streaming the Zoom meetings over Facebook. We're streaming also as well on LinkedIn. So it's not maybe on Zoom. If you guys are willing to go on Zoom, you have a link on LinkedIn if you want to join in. So actually I can have a good discussion with Professor Pera, who was the previous counsel of the Multilateral Investment Guarantee Agency of the World Bank. Here at Transnational Matters, we actually take care of international litigation, international arbitration, investment law, and focus on the multilateral treaties and advise clients to protect their investments. Okay, so how are you, Professor?
I'm fine, thank you. Thank you for inviting me. I'm happy to be here to answer any of the questions that all of you who are participants in this webinar, as well as give you information on the fundamentals that impact on foreign direct investments when they're made in third countries. So thank you for inviting me.
Absolutely, Professor. So we're going to start a PowerPoint that we prepared here so we can follow the flow of the questions. And the way actually it would be formatted, it would be in the fact that actually I'm going to ask a question per slide. Professor will actually introduce the answers. We got a bunch of questions to go over, Professor. Sure. And I'm sure actually this would be a very informative presentation and very informative to a lot of foreign investors out there. This is not based on legal counsel only. It's also based on the issues that in general investors or project managers may have down the line in oil and gas mining company, energy company, and so forth. So if we could go to the first introduction. Now, Professor, if I may, we know that countries entered into several treaties. If you can pull up the first slide. Okay, so we know that actually countries enter into several treaty agreements among themselves to develop financial and non-financial opportunities. But one of these agreements revolves around investment treaties. What are investment treaties and what are different types of investment treaties?
Well, let me give you a background before I describe or explain what investment treaties are. And that is that our discussion today will be solely based on investor-state transactions. That is, an investor who has a transaction with a state, with a third state. And it will be transnational insofar as the investment originates from one country and then the home of that investment would be in another country. So in order to protect those investments and promote those investments, countries enter and conclude what are called bilateral investment treaties. Up to now, there are about 5,000 different investment treaties among states, among many states, and almost all states aim to conclude these bilateral investment treaties. Bilateral investment treaties were preceded by another generation of treaties called the Friendship, Commerce, and Navigation treaties that preceded the conclusion of bilateral investment treaties. The laws and regulations governing internationally, governing investments into third countries are actually encompassed in these bilateral investment treaties. They form the foundations, foundational principles and legal principles that will apply for the protection of those foreign investments in developing countries. That's the most important fundamental criteria that need to be understood in concluding bilateral investment treaties. As I speak, the bilateral investment treaties, which are called investment treaties, are evolving because there are newer and newer principles that govern foreign investments for the protection of those foreign investments as they come out through transactions and incorporated in the new generation of investment treaties called International Investment Agreements, IIAs. So that is the new generation of investment treaties that really reflect principles and very much in detail as to how investments originating from a home country then is treated and protected in in a host country. And therefore, it is very important to understand that these treaties form the basic foundation in the event that there are disputes, in the event that there are issues and problems in a particular transaction, then it is this agreement or this bilateral investment treaty or the international investment agreements and the terms and conditions concluded in those agreements that will govern the transaction. But it is easier said than done. There are enormous complexities involved in when a transaction takes place in a host country. And I think that the best way to explain that is to look at actual real investment transaction. Again, as I said, today's discussion will be essentially on transactions or investments that originate from one country and then is hosted or invested in a third country.
Great. So basically, would we be fair to say that investment treaties are setting up the rights of investors to invest in foreign countries? Is that would be something that would summarize it?
Yes, and I would rather say that it gives a degree of comfort for the investor to know that under this bilateral investment treaty that will apply, that investment would be protected, that any issues that arise out of that investment will be generally governed under the particular investment treaties. Having said that, an investor must be very conscious about whether it has the nationality, whether it has the corporate nationality, or whether it has the personal nationality, or that can be protected under a treaty. For example, if the company is a US company going into, let's say, Ghana, then it is really important that the investor has the nationality of the United States. Whether it's a corporate nationality, whether it's incorporated in the United States, or if it's an individual, that individual is a national of the United States to get the protection of the bilateral investment treaty. So throughout the history of investments, investors are very conscious that if they do want to get the protection of the bilateral investment treaty, that they do have the nationality, the required or requisite nationality of the home country or the country from which the investment originates.
Okay, great. All right, so if you can pull up the next slide, please. So in certain ways, we know that foreign investors are entering in certain transactions and negotiations with the government. In that slide, you explain that how this transaction occurred. Can you please elaborate about how this works?
Yes. So now, if you look at the slide, and I hope you can see the slide, this is a hypothetical about particular hydropower transaction or investment in a hydropower plant, and the company is, of course, is called Power Up. There's no company called Power Up in the United States. I'm not quite sure whether there is, but this is really an example, a national example. And let's suppose that Power Up USA is the energy company or power producing company that wants to invest in Tropicana, another country. Let's say it's a Caribbean country called Tropicana, and it agrees to invest $50 million of its equity in this project. So what happens there is, now you can see that this is the transaction, but then immediately what happens? What are the legal implications of this investment? Firstly, Power Up would be very conscious about whether its investment of $50 million would be protected. And the first element to look at when Power Up does decide to invest this $50 million is whether this investment is covered by any bilateral investment treaty. And therefore, you will see that it has looked at looked at whether there is some protection for it, and it knows now that there is a bilateral investment treaty between the United States and the state of Tropicana. So how this happens is that this $50 million then is invested through its operating company. It just cannot operate a hydropower plant from the United States, where the hydropower plant is in Tropicana. So what it does is it has an operating company called Columbus, I think, Columbus Power Company, which is the operating company of Power Up in the state of Tropicana. So what it does then is, in order for it to operate its company, it needs to get the agreement of the Republic of Tropicana. So it enters into a concession agreement. How you will get into another layer of the legal implications. A concession agreement which necessarily shows that the government of Tropicana has agreed to Power Up LLC to operate a power company in Tropicana to provide 250 megawatts of power, hydropower, for use by Tropicana. So now that is reflected in a concession agreement between the government and the Power Up. And in that concession agreement, what it does fundamentally is to permit Power Up to produce 50, or I think it's 50 megawatts of power in Tropicana, and the government gives them certain guarantees. And the certain guarantees is that it agrees that there is a power company, there will be power produced, that the produced power will be distributed among consumers in Tropicana, and the government says, okay, these are the concessions that we will be giving you. These are the protections that we will be giving you. If there is a breach of the concession agreement, this is how disputes will be resolved. So there are so many elements and very complex. The concession agreement is fairly complex because it gives you what the obligations and responsibilities of Power Up are, and what the obligations and responsibilities of the government is, government of Tropicana is, in terms of the individual responsibilities, so that the project can perform its tasks and functions without any problems. So if we go then, now there's the bilateral investment treaty. The law that regulates the bilateral investment treaties are often international law, but in the concession agreement, you may have a very different law applying. Very often, negotiators of these concession agreements, that is, try to align the concession agreement and particularly the protections for the investment with the bilateral investment treaty. So now the operating part of this particular project will be that Columbus Power will then create a power plant and construct a power plant, which is actually foreseen in the concession agreement. They will create a power plant and then produce power. And when the power is produced, it is sold to a government entity. And therefore, it is just not sold just like that. They conclude what you call the power purchase agreement. And that is really a local agreement, the power purchase agreement, which gives you the terms and conditions under which this 50 megawatts of power that is produced will be sold to the power authority of Tropicana. And it will give you the tariff rates that will be applied to the purchase of power, so that Power Up in the end will get the return on the investment of $50 million. So the power is then bought by the power authority of Tropicana. And as you see right at the right-hand bottom of it, then it is sold to consumers. So the consumers then will pay the power authority. The power authority will then pay the local company, which will then declare dividends because it's an equity investment. And that is how Power Up in the end will earn its return on the investment. So this transaction is very important to give you a context of not merely a bilateral investment treaty applying to the transaction, but with the various other basic fundamental agreements that are in play that may have different legal implications. So it's very important to understand that the bilateral investment treaty in itself is very important, but there are underlying agreements like the concession agreement and the power purchase agreement in this particular example that I'm giving that is really important to understand. But I think we could continue with trying to understand what the bilateral investment treaty does, because that's the transnational or the international implication of this particular transaction.
Got it. So now we started to have projects of investment. If you can go to the fourth slide. And since we understand that the bilateral investment treaty and the concession agreement is giving some actually legal terms of how the transaction should be should occur. Actually, that's actually controls how the transaction should be in itself between the BIT and the concession. But let's say now that actually the government started to act up. So now we are at the stage that the government decided to expropriate. What would be some of the solution that a foreign investor should explore?
So beyond this, we've gone to the end really of a bilateral investment treaty, and it is the fundamental thing that fundamental aspect that investors really look for is to protect their investments from government's intervention into the investment. One way of doing that, one way that government can interfere in the investment is to directly or indirectly control that investment. So now, beyond that, there are several important elements that are there that also gives the investor comfort. One of those elements is that, is this considered to be an investment? There's a proliferation of investment disputes that ended up in arbitration, where the first question that was contested is really whether the investor has the right nationality, as I mentioned to you. So that becomes the jurisdiction issue. So in fact, whether the investment can be defined as an investment. Now, in this particular case that we talked about in Power Up, clearly there is an investment. So that's not an issue that will be taken up because there's a clear investment of $50 million into this power project. Then there is the other issue about nationality that also can be solved because the bilateral investment treaty, when in many bilateral investment treaties, these terms are defined. What is an investment is defined who is a national of each state party is also defined. And the next question sometimes is, what is the state's responsibility if there are disputes? Now here, there are more complications, because if you see that the origin of the issue, for example, in this Power Up case, if we think that there is a breach of the concession agreement, then we need to understand who breached the concession agreement. Was it the state? And what do we mean by the state? And that goes into a fundamental legal principle called state responsibility. In many ways, it's not the government that enters into these agreements. Sometimes it's government agencies like the power authority of Tropicana. As you would see, the power purchase agreement is between the power authority of Tropicana and the operating company of Power Up. So if the power purchase is breached and it amounts, the breach is so fundamental that it amounts to the collapse of the investment, could that be considered to be an indirect form of taking by the government? And can that breach by the power authority be attributed to the government, so that is where the bilateral investment treaty comes in? Where can the bilateral investment treaty be interpreted to mean that a state party means the government of that party and a government of that state party and its agencies and its agents and that are authorized to get into these transactions? So a number of complications. So now the issue of dispute resolution is clearly stated in many of the documents. So depending on what the facts are and what facts are involved in this interference by the government in the transaction, it is important to understand. And then there is the question of attribution. Who do you attribute it to? Can you attribute it to directly to the actions of, let's say, the Minister of Energy in the example that I cited? So that would bind the government of Tropicana in this particular transaction. Okay, so now once we determine, yes, the government is responsible, then we look at it in the form of, what does the bilateral investment treaty say? First thing is about whether the particular dispute, whether the direct or indirect expropriation, is covered under the bilateral investment treaty. And what does the bilateral investment treaty say about dispute resolution? For example, the concession agreement would say, if there's a dispute in the concession agreement, you need to go into the domestic courts first to resolve it. And then if you cannot resolve it under the domestic jurisdiction, then if the parties fail to do that, then and only then can you then accede to what is the dispute resolution agreement in bilateral investment treaties. And very often, and in most of the cases in modern times, most of the bilateral investment treaties, international investment agreements, do refer any disputes that are unresolved for remedy by the International Center for Settlement of Investment Disputes, otherwise known as ICSID of the World Bank Group.
So we're going to go to the next slide for this one, if you may. So we know that, for example, in state court and federal court, judges need to have a jurisdiction over the claims. So how does this jurisdiction determine investment disputes and what merits that could be brought on?
Yeah. So now, as I mentioned earlier, there could be conflict of laws. And meaning is that what law applies here, and that is determined in the bilateral investment treaty. It is international law that applies. In that concession agreement, it could be well that both Power Up and the government of Tropicana has agreed that because the project takes place in Tropicana, Tropicana law will apply. And if Tropicana law applies, who is best to apply that law than within the jurisdiction of the government of Tropicana? So what happens is that in the dispute resolution clause in the concession agreement, they may refer the dispute to the local courts. And so it's very important to understand, where is the dispute? Where is the source of the dispute? Is it an international breach, or is which can be covered under bilateral investment treaty, or is it clearly a breach of the power purchase agreement, which might amount to a breach under the bilateral investment treaty as well? So really important to understand that the transaction documents that are involved in this case and can be very, very complex. And when you said jurisdiction, this is what it means. I presume your question goes to, can this particular dispute, even if it is expropriation, be taken under the jurisdiction of, let's say, Tropicana in this particular hypothetical example? It certainly can. Now, what is sometimes agreed to the bilateral investment treaties is that even if it is so set, if the particular action, if the particular breach comes within the scope of the bilateral investment treaties, then investors are not compelled to go into domestic jurisdiction. Although the international legal principle of exhaustion of local remedies that are there, particularly in transaction documents, need to be applied, but it can be circumvented if the bilateral investment treaty and the language in the bilateral investment treaty clearly states that there is no need to do that you can go directly into international arbitration, provided the dispute resolution clause also says that you need, and in these particular circumstances and in this new generation, they really do emphasize that if you can settle this dispute within the confines of the domestic jurisdiction through going to the local court, then do so. And if you cannot resolve it within, let's say, 60 days or 90 days, then you can go to the international arbitration, the resort to dispute resolution internationally.
So, Professor, I have a question regarding the claims on their own when they started to initiate disputes. What are prescription periods? Are they the same as statute of limitation of following, for example, the Florida statutes? Do they have a certain amount of time limits to bring on these claims before they actually are too late in the game?
See, this is really very important because that is also determined by the transaction documents. And again, the concession agreement, if that is the law, again, on the hypothetical, is the law of Tropicana, then one has to look at what the law of Tropicana says about filing a claim. And they have, if it says no claim can be filed against the government or any government agency before the period or after a period of 5 years or 10 years, then those statutes of limitations will apply. You and I know, in a recent example, no names mentioned, there was this question of the prescription period. Although the particular action came within the bilateral investment treaty or the trade agreement between the two countries, there was this issue that has the investor interrupted the prescription period, or does the prescription period apply? And that's a defense for the government. The government, as a respondent, will say, well, you know, it is true that there may have been a cause of action here. However, the investor is required under the law of, let's say, Tropicana now, that any action must be pursued within 5 years, that's the prescription period. Essentially, the reasoning behind is that you did not do anything to resolve your dispute or to recover for the 5 years prescriptive period that is statutorily applied in the concession agreement or the power purchase agreement. And that stands to reason because it shows that the investor is really pursuing a remedy within the time allocated for that. And that's a fundamental and general principle that applies to any law that is in force.
Right. And so when does the prescription period start to run? Is it when the claims happen or when the breach occurred, or when the investor just exhausted all his legal remedies in local courts?
No, the prescription period is a period of time within which the investor should pursue remedies. So it starts with the dispute when the dispute occurred, when the breach occurred, and there is a certainty in date that after that there was no way that the investor could have had access to any remedies, and that's when the period starts. So immediately upon that date of the breach, when the investor has said, look, I have written to these to the government authorities, I have tried to speak with them, here is the evidence that I did, but there's no resolution to this, there's no reaction from the government, and therefore I have no remedy right now to exercise other than go into the local courts, as the concession agreement would say, or go directly to arbitration, as the bilateral investment treaty would dictate, depending on what the cause of loss was. So causality is very important to understand how the loss occurred and how the loss is recovered.
All right, so we know that in international arbitration, there are several tribunals, such as the International Chamber of Commerce, the Permanent Court of Arbitration, the London Court of International Arbitration, and so forth. However, how is ICSID differing from these courts and tribunals? What is the main function of the International Center of Investment and Settlement Disputes?
Yeah, so most of the other institutions that you mentioned, International Chamber of Commerce, the Permanent Court of Arbitration, London Court of International Arbitration, they can take both commercial arbitration as well as any other type of transaction or dispute that can come within there. Each one of them has what they have is jurisdiction or rules under which any disputes can be brought. The distinction between every one of the others that you mentioned and the international settlement of investment disputes is that ICSID arbitration is restricted to disputes between investors and states. So it's called investor-state dispute resolution, and it is exclusively the function of the International Center of Investment and Settlement of Disputes. Here, their exclusive function really is to look into disputes between investors and host states. And host states, investor states and host states that have subscribed to and have signed the Washington Convention for the creation of the International Center for Settlement of Investment Disputes, ICSID. So again, the exclusivity is what distinguishes ICSID from all other institutional arbitration forums that you can find all over the world.
All right, if we can pull up the next slide, which will bring you up to my next question to explore on the issues on the rules of ICSID.
Yeah.
We know that ICSID has several rules, and they include the expedited rules and rules on mediation. What would you recommend for investors? Which rule they should use, and when should they consider using the expedited rules and the rules on mediation?
I think before we go there, because these expedited rules and rules on mediation are very recent, I think it might be useful for us now to see whether any of our participants do have any questions that we might want to explain, because we've now proceeded quite a bit into ICSID, where we're approaching ICSID
Right.
as well.
Right.
And ICSID's expedited rules and rules of mediation really are very recent. And there was a reason why ICSID adopted the expedited rules as well as the rules of mediation, which was last year, March 2022. So I think it might be very good, Mr. Carson, if we can take any questions up to now from those who are listening in and participating.
Absolutely. Okay, and so we'll finish with the last slide, Professor, so we can open the floor to questions. I don't want to take too much time on the presentation for everybody, but so if we could just pull up the, okay, so you used to work at the Multilateral Investment Guarantee Agency. And we've been speaking about when the government expropriate assets or does not follow its treaty contractual obligation. But you came from an agency that insures investments. Can you elaborate on the function of MIGA and how investor insure its investment with MIGA?
Yes, and MIGA is really what one calls an agency that protects investments. But as I said, should we go back a little bit?
I think this would be very important because a lot of investors, what they do, they do not know what MIGA is.
Yeah,
and how it
so
functions.
in that case, should we get back to the previous one and let's talk about the exit rules?
Perfect.
And then go a little bit on to exit expedited rules and rules on mediation, why they thought it best to have expedited rules and rules of mediation. Now, if you go to if the bilateral investment treaty and many bilateral investment treaties refer investment disputes to be resolved ultimately under the exceed rules and procedures for dispute resolution, primarily through arbitration and conciliation. Now, there are a set of rules for conciliation, differs from mediation, and I'll get to that when I talk about mediation. But in general, since 1966, when ICSID was created, they adopted a set of procedures and rules that arbitrators are required to conform with, and both the applicant and the respondent are required to conform with in pursuing arbitration. So let's assume that it is an arbitration, then immediate set of rules will apply that both countries have agreed to by conforming to the standards and principles that are included in those procedures and rules. So it's fairly complex, it's long drawn out, beginning with both parties giving written agreement that the dispute can be and should be resolved under ICSID rules. And what do I mean by that? That it is automatic if the particular dispute comes within the bilateral investment treaty that applies, and the dispute resolution clause there referring any dispute to ICSID, so for resolution. So there while the rule says there has to be written agreement between the two parties, because the bilateral investment treaty has been concluded between the two state parties, which permit an investor having the nationality of one of the parties to pursue arbitration against the other state, which is also a signatory to the ICSID convention, that would be presumed by ICSID as a written agreement that the dispute should be resolved under the aegis of ICSID. Now, after having said that, then the procedures will apply. Both parties will have to state what the claim is all about, and whether ICSID has jurisdiction over the claim. A party will assert that this is, for example, an expropriation, direct or indirect expropriation, and therefore under the bilateral investment treaty, which has defined or explained what a direct or indirect expropriation is, that the tribunal has jurisdiction over the particular action or course of action. And then, of course, ICSID, under the ICSID rules, each party has the right to appoint an arbitrator, which is not of their nationality. So each party will appoint an arbitrator, and both parties will agree to the president of the arbitration or the third party arbitrator, who often is the president of the arbitration panel. and that's how, and if they can't agree on the third party arbitrator or the president of the arbitral panel, then ICSID's administration will propose to the two parties candidates who can take the third party arbitration. So there now we have the arbitration panel. Then the dates are set. Well, there are fees involved, depending on administrative fees involved, depending on the amount of being claimed. And there are claims going from a mere $50 million that are disputed to $1.8 billion. The spread for compensation can be huge or minimal. There's no minimal, but in terms of costs incurred, it's people don't take causes of action with minimal damage for full stretch arbitration. And so then there are, when you go into arbitration proceedings as well, you have the two major elements the fundamental of arbitration, which is jurisdiction and merits. So each of the parties will, there is the statement of the claim, then the legal submission of the claim, and then there's the respondent's submissions and respondent's legal statements with counter arguments that are placed before the arbitral tribunal. And then if the tribunal has been set up, if the three arbitrators have been appointed, then the three arbitrators will sit down and resolve the case. And they try to resolve the dispute. And there are oral proceedings that are called. And now with virtual possibilities, they can carry the whole process by virtual presentations. But this whole thing will take, on an average, 3 to 4 years before the tribunal could conclude and have an award. Now, the important thing here is to understand that once you go that route into arbitration and both parties have resolved that there is no other way than to go into arbitration on this matter, it can be very, very lengthy, because each one of these issues, legal issues, like the nationality of the claim, or whether there has been an actual investment, each one of these issues, both jurisdiction and merit, can take a long time in terms of having evidence produced to show on one side or the other of what the contested issues are before we even get to the merits of the case. If it is an expropriation, whether there has been an expropriation, whether there's direct or indirect expropriation, and then finally computing the damages or compensation, which is a very, very, very complex matter to resolve. So these arbitration proceedings can take as much as 3 to 4 years on an average.
Wow.
I have known cases that go on for 10 years. And so the cost is phenomenal. Cost of arbitration is phenomenal. Payment of lawyers, payment for the tribunal members, the arbitrators. So the cost can be really phenomenal. That is what precipitated the adoption in March of last year, 2022, the adoption of ICSID's expedited rules and rules of mediation. Expedited rules because of the length of an average tribunal hearing, very often really being constrained, for example, for a lack of evidence, getting discovery rules underway, requiring that this evidence will be produced. This can take months and months and months. Objections then looking at confidentiality issues with when it comes to documentation. This is really it prolongs arbitration. So arbitration process. So ICSID, given the pressures involved, adopted into the expedited arbitration rules, in which the appointment of arbitrators, the length of time has been shortened significantly. The advanced costs that has to be submitted has been reduced, and there is a timeline that has been adopted within which certain aspects can be briefer in terms of submission of evidence and things like that. I'm not very familiar with the details of the expedited rules. It has been adopted, and I've not studied it, but I did study the rules on mediation. Now, why did they adopt mediation? They already have conciliation.
Right.
The mediation is a much more informal method of resolving dispute. And very often, both the investors who are having dispute states, they both agree that they can agree to settle this dispute because the costs are phenomenal. Right. And the longer the arbitration proceedings, the more costly it becomes, more and more costly for both parties. And very often poor countries which are not or less developed countries don't have the amount of costs or to hire attorneys to defend the case without really incurring costs that can be really phenomenal. So mediation is now very much a mode by which or alternate dispute resolution mechanism by which the investors can, after having a dispute, or even when it feels that this particular issue might turn into a dispute, can sit very much earlier with the government and say, look, we've got into this conflict situation, let's try to amicably solve this, because this can be done. And there is really experience that we were going to talk of the Multilateral Investment Guarantee Agency, and myself, when I was in the Multilateral Investment Guarantee Agency, where its intervention really brought about dispute resolution very quickly when a problem arises, where both parties will come together and say, let's settle this. What are the core issues here? Let's settle this. Right. So, and that's the thing about mediation. It's very informal. It's the weaknesses of mediation, of course, it's non-binding and it's without prejudice. So whatever is agreed during mediation, and if the mediation fails, that evidence of whatever is agreed to cannot be produced before any judicial forum or even an arbitral forum. And that's important to remember. Unless the two parties agree that, yes, the mediation might fail, but we've agreed that you have a course of action. You have the proper nationality, but we don't agree with your costs, the costs incurred. That has to be distributed. So if that fails, then if the parties have agreed, yes, whatever we agree we can produce before the arbitral forum, then we can. But if it is without prejudice, then the problem is that whatever you have agreed, it doesn't matter. In arbitration, you cannot produce any evidence or any agreement that has been reached in mediation before an arbitral tribunal, unless, as I said, the two parties have agreed to the.
All right. So we'll go to the next slide in that matter. So you talked about the Multilateral Investment Guarantee Agency. Can you please elaborate how investors can ensure the investments and how this can deter government's expropriation on investments?
It's not merely expropriation. Well, let me give a bit of background of the Multilateral Investment Guarantee Agency. In 1982, the president of the World Bank, in in his annual statement said that the World Bank was exploring this possibility of creating an agency that would provide an insurance scheme for investors who are concerned about political risks that might intervene in their investments, that the whole state might intervene in their investment to an extent that the investment fails. And therefore, it was thought that there could be an international organization, an apolitical international organization, which could be created for the purpose of giving confidence to the investors that we would cover any of the political risks that they are concerned about that would cause ultimately the loss. And it was restricted to political risks, which means the government deliberately coming in and then taking over the property of the investor. Said expropriation, nationalization. Here in the United States, expropriation, nationalization is called eminent domain.
It's a very nice name.
Yeah, it's much nicer than expropriation. I agree. It's much more dignified.
Yes, it's more like you can reason with it.
As I say, well, expropriation and things like that occur these poor developing countries. Eminent domain.
Very beautiful.
Happens in the United States. That aside, it's the same thing. So that was the whole idea behind the multi-extraordinary agency. So there was a convention that was prepared, and during the annual meetings in Seoul, Korea in 1985, member countries agreed to create this organization to allay the concerns of political risks that are encountered by investors. Whole objective of MIGA, or the Multilateral Investment Guarantee Agency, as an agency of the World Bank Group, is really to promote foreign investments. It's not a prevention as such, but to promote, so that it gives confidence to the investors that wherever they go into the developing world, with investments that can be exposed to high risk political actions, then those concerns can be allayed. So there were 4 types of risks, and when the organization was being created and during the proceedings that was discussed, a lot of research was done in terms of identifying what are these risks that investors are concerned about when it comes to them really deciding on investing. So one of the main concerns naturally was expropriation, nationalizations. You know, in the 60s and 70s, coming out of colonial regimes, the former colonies decided to take matters to their own hands in controlling their own resources. A whole huge spate of expropriations and nationalization, actually beginning as far back as 1917 with the Russian Revolution, which really was one of the first cases cited in arbitration called the Lena Goldfield arbitration, because once in 1917, when the Russian Revolution occurred, all of the foreign investments there were nationalized. So was it in Cuba. So was it in most colonial countries in which the resources which were controlled by home countries or investor states were taken over in large scale manner, with its oil and gas, copper in Chile. They were taken over by governments who were socialist minded. The resources belong to the people, and they should be the beneficiaries of the exploitation of those resources. Right. So that is one aspect of MIGA's political risk coverage both indirect forms and direct forms of coverage. A direct form, of course, of expropriation nationalization, which used to be the case, is that the government says, henceforth, this property and this investment now is transferred to the name of the state. It is now state property. Whether compensation is to be paid or not belongs is within the sovereign right of the country that expropriates or nationalized. I mean, in Mexico in the 1920s and 1930s, agrarian and oil and gas properties which belonged to the United States were taken over by Mexico. And the question—
Is that a Metaclaw case?
no, Metal-Clad was much later. These cases brought about what one calls now the Hull Doctrine. That is, that both countries, both the United States and Mexico, agreed over correspondence between their secretaries of state that expropriation is a sovereign right of the country, but it should be for a public purpose, non-discriminatory, but it should be accompanied by prompt, adequate, and effective compensation.
Right.
So that said, many countries took over properties but never paid compensation, which led to a slew of arbitration cases, going to even national jurisdictions and trying to recover losses. So Metal-Clad was a very recent, but that's a direct form of expropriation where the ownership and title reverts to the state that is expropriating. Now, the more complex stuff is the indirect form of expropriation, which is the government indirectly assumes rights to the property or intervenes in such ways that the investor becomes, it is not viable for the investor to run its investment anymore. So it literally negates the rights to the property and also the benefits deriving from the property. So that's expropriation. The second concern that, so that is covered by the multilateral MIGA. The second concern is that the investors go and invest in a particular country. As I said, in this Tropicana case, the consumers are given electricity, they pay for the electricity in local currency. And then they give it to the authority, then the authority gives the local currency to the operating company for further transmission to the parent companies, which is Power Up. Now, Power Up doesn't need Tropicana currency.
Right.
So Power Up requires the dividends to be declared in the foreign currency and then repatriated. So what MIGA does is they are concerned and they cover the investors' concerns that yes, we may be able to get the local currency, but we may not be able to convert the local currency into foreign currency and then expatriate. Numerous examples: Russia, Nigeria, Argentina, Venezuela, they all had this point of, well, their income is generated through local currency, but they're unable to convert the local currency into foreign currency or the currency of the investment and then have it expatriated. So that is covered by MIGA. These are two fundamental. And then the third one is war and civil disturbance. Loss due to war and civil disturbance. Investors are very concerned. And they have lost property because of war and civil disturbance. War and civil disturbance, see what is happening in Ukraine.
Right.
With the Ukrainian war. Anywhere there is civil disturbance and war, investors' properties are vulnerable to destruction and they often cannot recover. Now, Multilateral Investment Guarantee Agency, MIGA, does that. They cover destruction of property due to war and civil disturbance. It's very difficult to recover in subrogation, but it is something that MIGA does cover. And the fourth is a very interesting nuance, which is called breach of contract coverage. Now, breach of contract itself, now we saw the concession agreement in the Tropicana example, and also the power purchase agreement. under international law, because of privity of contract, under international law, the breach itself cannot be covered because of privity of contract. So contractual terms apply. What can be covered is that after a breach of the contract, there is an arbitration and there is an arbitral award, right? Arbitral award that is in favor of the investor. Now, the investor is not able to enforce the arbitral award. So what MIGA covers is the non-enforcement of an arbitral award.
Okay.
And that is what is covered. And that is what takes you to the realm of international law. Non-enforcement of arbitral awards by the government deliberately is a breach of international law. So that is why why MIGA can cover breach of contract and non-enforcement as a measure. So those are the four political risk issues, and there are nuanced coverages. For example, government guarantees and all that sort of thing that comes in under these four different risks, what are called political risks. So that's the function of MIGA. And MIGA independently also does this mediation work. The great strength of multilateral investment guarantee agency is its leverage. It is, after all, there are two elements to this. It is, after all, a World Bank group agency.
Right.
And many member countries will not try
to play around.
try to make things difficult for themselves by interfering in projects that are really clearly covered by a World Bank group agency. That's the first thing. And the other really important characteristic of the leverage that the multilateral investment guarantee agency is that, after all, MIGA is owned by member countries. Right? They have shares of MIGA. So why would they take action against their own agency? Right? In the end, we will come after them as a shareholder. So that's a very important leverage. We often, in our mediation, in my experience, the government look, why do you want to take this action? I mean, you're hurting yourself in the end, and you're also inhibiting investors from ever coming to the country again. So let's settle this. And so this mediation, incentive for mediation to taken up by ICSID really came from a lot of experience which MIGA had in settling disputes very early on. And in many cases, the investment was, the dispute was resolved to such an extent, the government, in fact, gave even better terms to the investor. So that's the importance of mediation, whether it is now taken up by ICSID, or if MIGA continues to do that as well.
Okay.
Yeah.
All right. So we're going to go to the last slide again. And basically, so we would like to thank you, Professor, first for your time and sharing your knowledge regarding investors and state dispute settlement. We would like to give the floor for questions or anything that would be open for questions right now. Okay, so we have a question. So what is the best way to streamline the process so that arbitration does not take a long time, as Professor Pera stated before?
So now we know that since March 2022, we have the expedited rules. So it is really important to study those rules to see if you, as an attorney, is advising your government, or if you are advising the investor in a particular case, how do we then streamline this or process this in ways that will expedite the outcome of the dispute? And that all depends on how you do it, how you advise your client, or when I say client, it could be the investor or the government itself, to ensure that there is no unnecessary delays that are encountered. So that's the whole thing here. Now we know that surely that if you are going to exit, if an applicant is going to exit, then the exit rules apply. So it's really, really important to study the exit rules and then how exit rules are going to be applied. And we've concentrated quite a bit on exit rules because that's the key investor-state dispute resolution entity. Now, I would say if your question is really how do you ensure it, it all depends, as I said, on various criteria, who you appear for. If you're on the side of the investor, if you're advising the investor, then understanding the investor and producing mostly the issues around issue for the investor, issues around the absolute evidence that is there and that you have in a timely manner got all of the evidence that is required to submit your application and process the claim. If you are advising the state, one of the main problems is really to ensure that the state is protected against unnecessary judicial actions or arbitral actions taken by the claimant, and very quickly understanding the rules that you give in your responses, a detailed analysis of the state's case. So this is something which I cannot tell you about or advise you on, except if I'm asked by the state or an investor as to, okay, how do we now make sure that this process takes place in a seamless manner. There's nothing called a seamless manner. There's always the wrinkles that come up as you go through proceedings, but we have to try. So very difficult question to answer. The good thing about institutional arbitration like ICSID is the rules are fairly predictable. Interpretation and definitions can become fairly difficult at times and complex. To go into the case law to ensure that the problem that you have identified as causing part of the loss is thoroughly vetted, and there is case law to support your case. All this requires a lot of preparation, and preparation is the thing to ensure an expedited of achieving your goal, which is to get compensation if you are the claimant, or having the claim rejected if you're advising the state. So yes, and that's a great question, and I cannot give you a better answer. So the best, I mean, one of the great things now is that the rules are fairly streamlined, and expedited arbitration is fairly streamlined. So that's the good thing that one encounters.
And basically, it's very hard, just like in the litigation, it's very hard to predict how long the litigation occurs. But now we have those case management deadlines, which streamlines the litigation and makes things faster here in Florida. So that's why I believe that we can compare the expedited rules on arbitration to these case management deadlines, to which the Supreme Court of Florida started to take action to try to diminish the dockets of state courts here in Florida due to the fact that COVID occurred. And I think actually that's what ICSID took results from. I think that's COVID
perhaps
have a reason for why they wanted to have the expedited rules.
Yeah, but even before COVID, I think there was real concern among applicants as well as respondents that these things take such a long time, and the longer it takes to resolve, the more costly it becomes.
Of course, and this is why also with the transnational matters, we try to cap our costs. I just want to say we cap our costs to a certain extent, so we don't be over costing the clients to when we deal with investor state dispute settlement. But we have a second question that follow up with these issues. Are all countries bound to exceed rulings? How does that work?
No, they are not bound by exceed awards. In fact, exceed awards on the same facts. Could differ in their conclusion. One arbitral panel could conclude that there is no expropriation given the fact patterns of the case. Another tribunal on the same fact patterns of the case might come to a different conclusion and say, yes, here there is an indirect expropriation. One arbitral tribunal might say, this is the total amount of compensation that can be awarded as the applicant has requested. Another tribunal will come to a different calculation model and say, no, this is unjust for the amount that is requested to be given in the same manner, and might reduce compensation. So nothing is bound, and that's the thing about arbitration. There is no stare decisis. No, nothing is the outcome. It cannot be predicted.
Right.
It all depends on how tribunals look at the same factual cases. As I said, there is no stare decisis, so the decision of one court is not binding, but it is persuasive. Many cases that are cited in awards by tribunals cite previous cases that have pronounced on the same fact patterns.
And so I just want to reiterate something. When we say when it's a binding, that means a tribunal does not have to follow a similar case that has been in a similar situation,
Right.
Per se. But however, is the award itself is enforceable under the New York Convention.
Absolutely.
I believe it's 160 countries that have signed up to the New York.
Yeah. So now we go into a different phase. Now the ICSID award is binding, final and binding, as if it was an award or a decision by the highest court in any member state.
Mhm.
So that is how it is characterized. Now, that is one thing, but to then try to get the award enforced is another matter, and it can be extremely complex. And that's the other problem with arbitration. To the extent that member states recognize their obligation and responsibilities and then pay compensation, it is binding. So, right? If they do refuse to pay compensation, then you go into a very different litigation process enforcement. So the first thing that countries are required to do when the government is not recognizing the award which they were participant and is not paying the compensation due is to go back to that member state and then take enforcement actions in that member state,
Right.
so that the government then pays up. If they still refuse to, or if they fail there, then you have what they call an asset chase, where under the New York Convention, you go to countries that have signed on to the New York Convention, go to their jurisdictions, locate assets of the state, most commercial assets, not sovereign assets, that's another problem. And then go into the courts there, where get an exequatur from the highest court or the applicable court, and then go after the assets and get the asset in lieu of the award. One example was, what can I cite? Example was an award that was an arbitral award that was not recognized by Argentina, and Argentine commercial ship docked in Ghana in the port of Accra, and they went and got an exequatur in the Ghanaian court, and then seized the ship, sequestered the ship in lieu of the arbitral award. So things things like that can happen. But very often, if I recall, most of the exit awards have been recognized and paid.
No, of course. And so I have another question that somebody asked about citizenship. That citizenship matters when pursuing an action in exceed. Now, I will try to answer this briefly, and you can elaborate more based on this answer. I think actually exceed has a problem with dual nationalities. If the claimant has a citizenship of the host state when they start an action at the with the exceed rules, then we started having an issue of jurisdiction over the claims, because exceed does not necessarily all the time recognize dual nationality. We had cases in the past where a claimant had the nationality of the host state and the nationality in the US, another state. So this is really a problem. There were exceptions to the case, and I believe that you can see that there are some exceptions on how the investment was made. But this generally the exceed rules is against it compared to industry control rules. Am I correct on this?
I do not think that is the case. The problem is really an omission,
right,
on the part of exit. The exit rules talk about investment of a national of a member state, right, bringing a dispute into arbitration against the host state or the other signatory state. So it doesn't say about national. So by that, the determination of nationality, which is indeed a jurisdiction issue, is determined by international law now. And that really is at the heart of the issue. Now, it should be a national of a signatory state. So it's an omission that who is a national of an investor state. Now, we know that there is corporate nationality and there is personal nationality,
right?
Okay, individual nationality. In terms of corporate nationality, there are issues, but it is where the corporation is incorporated. So it's Power Up Company is a corporation incorporated in the US, United States, and therefore it has the nationality of a member state, which is the United States. So they can proceed into arbitration. But let's say that there is a individual national that has the nationality, that has dual nationality, both of the United States as well as another member country.
Right.
Now, what applies there? Certainly, there can be objections to the objections raised by the host state or the respondent state, saying that this is also a national of my country.
Right.
Okay, so he can't proceed. The rationale being a citizen cannot proceed against its own country in international arbitration. Its only right is within that country.
Right.
You want to resolve a dispute as, let's say, Tropicana national, you have to go to the courts of Tropicana. You cannot use your other nationality to bring this. So now in 2006, 2005, the International Law Commission came up with what one calls the draft articles on diplomatic protection, which goes into the question of dual nationality. When one of the nationalities is indeed the nationality of the host state or the respondent state, then it goes into detailed factors in terms of determining the applicable nationality. Right. So the question of in what capacity, when it invested, did it invest as a national of the home country or the United States, or did it invest as a national of Tropicana? What is the investor's habitual residence?
Right.
What traditions have they accepted? Who is they married? What is the habitual residence? What are the traditions that?
So now we come to a jurisdictional issues.
Yeah, so these are in evidence. This is in evidence, and then they determine and what the diplomatic articles of diplomatic protection of the ILC, they're draft articles, not binding,
Right.
but really the principle is the dominant and effective nationality.
Nationality. Okay.
And it's very, very complex to determine that. It's a whole series of cases on international law. So there is the Mikula case that came into force because the investors had Romanian national. That's one of the key. Went to Sweden, got Swedish nationality, but investors invested in Romania, Swedish
Right.
nationals, and then the whole question of was were they dual nationals? No, it turned out that once you get a second nationality under Romanian law, you lose your nationality. So when they invested, they actually, although they were Romanian born, they invested as Swedish nationals. So it is a complex issue. It will always be contested. And then you have even under corporate nationality, we have the famous Barcelona traction case, which gives the guidelines that it is not the shareholders' nationality that counts, but the corporation nationality that counts.
And it's always going to be an unresolved question about dual nationality.
And it's a jurisdiction issue.
Very
jurisdiction. It's a preliminary
jurisdiction
issue.
If we have to compare this in the United States, in local courts would be under the minimum contact test to see whether it actually is a subject matter or in personam jurisdiction.
In personam jurisdiction.
Right, most of the time. But here, I have another question, and I don't know who asked it first. Did you happen to know who is somebody asked, can we go about evaluating our case, international case with your team? Do you recall? Just want to talk to that person. I believe that for you to do that, we prefer that we do it in privacy and talk to like on 1-on-3. We're willing to actually have a conversation and take our time to see what's going on in your case and whether you should pursue it or you should not pursue it. This is on a case-by-case basis. All we know is that our law firm is trying to be more cost-effective to bring on these claims and be able to work with the client and something that they can work with us in order for us to represent the clients at exceed levels, and also as well trying to prevent these things from happening. We just don't want actually things to be expropriated. We want to advise the client to be fully protected. We want the clients to be advised to be also insured. So whoever asked that question, please give in contact with us. We will gladly discuss with you on 1-on-1. This is a very specific on a case-by-case basis. And I'm sorry? You can go on the website called www.transnationalmatters.com. You can directly contact me on LinkedIn if you want to discuss that. I'm willing to give you the information right away. And if you need anything else, we can help. If you do have a case that's been happening on an ongoing basis, we will, if you'd like to discuss it in private and in confidence, I think this would be the proper time to discuss this as a private on 1-on-1 meeting with me and the professor. I think we can give our time to whoever asked that question to help them out on the case. But other than that, we look at the case, we look at the facts, and we see it's very hard to determine exactly the outcome of the case because it's a very lose-lose situation. It's a very, very broad situation, actually, and vague. This is the legal world. It's always going to be evolving and dynamic. So we never know how a tribunal will rule on certain claims. As Professor Perrin stated before, decisions made in prior cases are not binding. They're only there to kind of convince the tribunals to rule and follow the previous cases. But that's very difficult to actually determine. So that's why I say we need to discuss this, and you can have our contact information. I think our legal assistant is willing to provide it to online and help us out for this matter. If you want to get in touch with us, we're more welcome to give that time for you. We have one more question here, or a couple more questions, two more questions, Professor, if you don't mind. Are there countries that you would advise to refrain from investing in based on past history that they should be involved in taking assets over from the investors?
Well, that's a very subjective subjective question that goes into intent of states. Do they compensate even if they do take property? Those are criteria that need to be, if you're asking us about any blacklisted countries, I'm afraid I'm unable to answer that. I don't think there's a country called a country that is blacklisted, and that is the perception of the person involved. And there could be a country that is producing diamonds, but in complete political turmoil, but yet those who want to undertake the risks of investing in this to explore diamond, the government probably will say, okay, do come, we'll come into an arrangement. And in which case, if you want to take the risk, look at how you want to how you want to protect your investment. Yeah, does that country, even if it is blacklisted, does it have a bilateral investment treaty that is
That's the most important part.
is it a member of ICSID? Is it a member of MIGA? In which case, you can apply to MIGA to have your investment covered. One can always do that. So it's a lot of criteria when you make the decision to invest in. Investors don't go and invest in countries for any altruistic reasons. They go to get the maximum amount of profit and return on their investment.
They don't look at the legal consequences.
Yeah, and also
we do that.
So it's really important, even if the country is risky, and I don't believe in blacklisting countries as such. Yes, some countries are much more riskier than others. I mean, you're not going to go and invest in Ukraine right now. There may be a lot of opportunities there, but so long as, excuse me, but so long as the war is going on, no investor in their right mind might go and invest there. But then again, who knows?
Maybe there's a reason why investments should occur. But
yeah, there's a quick return on the investment. A lot of investments that could even go into a hell to see if there's a return on.
I mean, you wouldn't want to invest in North Korea.
Yeah. Well, you never know.
You never know. Maybe one day we open up the VIT treaties and negotiations.
But here's a guiding principle. If there are sanctions imposed on a particular country, I think by one country, let's say the US now has imposed sanctions on Russia, it will be illegal for US investors to invest in Russia any longer.
Right.
So that is what the sanctions are all about. Those are the criteria that one has to take into account in making a decision as to whether one wants to go ahead and make an investment or not. And in many countries, the investments are discouraged. They want to control. A very good example is Myanmar, which opened up and now closed again.
Right.
That they don't need investments to have to run their economy. They will manage their economies when they were a closed economy anyway. So
all right. Well, we're coming to our end of the presentation, and again, if you need any questions or anything, please do contact Professor Pera. I think you're really active on LinkedIn as well. Sometimes, and maybe sometimes on Facebook if you want to.
Not so much Facebook as much as LinkedIn. Yes, professionally, you can always Google me. I formed a little consulting company in association with with transaction matters of Mr. Carcason, and it's called International and Transnational Investment Law Consultants. So you can find me there, but in LinkedIn is one of the best ways to initiate it. Initiate links with me, but it would be good that if you contact my colleague here, Mr. David Carcason, who's very enthusiastic and very energetic. And if he thinks that I need to be involved in a very particular case, then I'd be happy to advise you on such matters through a transnational matter.
And most likely you will, Professor. This is something most of the time we deal with international cases, Professor.
Right.
You come in here as an expert in international law, and you advise the firm and you advise the clients, help us to guide us through this process of ambiguities that we tend to go across. Last time was an acquisition that we actually were working on together and have to do deal with under the ICC jurisdiction. But without further ado, we're going to end the presentation here. Thank you for everybody to come in. And again, feel free to contact our transnationalmatters.com and contact our firm if you have any issues. We're willing to evaluate your cases. We're willing to sit down and speak with you if you have any other questions.
Thank you very much.
Thank you, Professor.